All right. Let's be on the record in two cases, those being 2017 CR 938 and 2020 CR 631, both captioned State of Kansas versus Eddie Johnson. Would the parties announce their appearances, please?
State of Kansas appears by and through Assistant District Attorney Garrett Rell.
May it please the court, defendant Eddie Johnson appears through David Matthews.
All right. We are here in the 2020 case sent down for a sentencing. In the 2017 case, there was an outstanding probation violation filed. The parties believe that they have resolved that. For the record, the probation officer is joining us this morning. All right. So let's take up the sentencing first, and then we can take up the revo after that. In the sentencing, I will find that the parties were last in court back on October 23rd, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted, ordered a pre-sentence investigation, and set it for sentencing today. I've received that pre-sentence investigation. The critical findings are as follows. The sole count of conviction is one of possession of marijuana with the intent to distribute. That's a severity level 3 non-person drug felony. The defendant's criminal history score was found to be that of G as in George. That would leave him with a presumptive prison sentence and a presumed underlying range of 51, 54, and 57 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to post-release supervision duration of 36 months. Special rule number 9 is in play in this case, in that this was a crime committed while he was on probation for a felony. If he's granted probation today, it would be for a period of 36 months to community corrections. First, Mr. Relf, I would ask you, did you get a chance to review the pre-sentence investigation? Any additions, corrections, or challenges thereto?
Judge, I did get a chance to review the PSI. I have no changes or modifications.
All right. Mr. Matthews, you filed a motion for a downward dispositional departure. Would you like to be heard on that today?
Yes, Your Honor, I would.
All right. And I guess I skipped over any objections or challenges to the PSI.
No, Your Honor, no corrections or challenges.
All right. I'll adopt the findings for today's hearing and hear your comments on your motion, Mr. Matthews.
Thank you, Your Honor. Your Honor, I would note that this defendant did plead guilty to the charge. He waived his preliminary hearing. If the court looks at the file, you can see that this moved pretty fast. So we were able to get this resolved quickly without the state having to bring in witnesses and officers and having a trial. So it saved them significant resources. I would note that the plea agreement is part of the probation, so we would ask the court to consider that as well. I would point out to the court that he has strong support from his family. They've called me several times. They're very involved and active in his case. And I do believe they're going to be able to help him, support him if the court does grant this motion and place him on probation. I would note, Judge, that obviously the attorneys look at the case and the different facts and not the court, since we haven't had a trial. But I would note that the evidence in this case at least shows that he was with someone else who had admitted to some of the marijuana. A lot of the marijuana was found under the passenger seat, not the driver's seat where Mr. Johnson was. I'm not saying that to say that he's innocent, just that one of the factors the court can look at is the relative culpabilities of the parties. So for those reasons, Your Honor, I would ask the court to grant the departure motion and grant probation today.
All right. Mr. Relf, comments on defendant's motion and anything else touching upon sentencing today?
Judge, I would just ask that you follow the plea agreement.
All right. Mr. Johnson, now's your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I understand everything that's going on. Yeah, I appreciate the probation.
All right. Thank you. Mr. Matthews, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. I'm going to grant the defendant's motion for a downward dispositional departure, and I will adopt for the substantial and compelling reasons to support that those set out in the defendant's motion and defense counsel's comments today, I do believe that they do constitute those substantial and compelling reasons. Therefore, the defendant will be sentenced to a period of 54 months in the Department of Corrections. If he has to do that time, he'll be eligible for 20% good time credit and subject to 36 months of post-release supervision. His application for probation today is considered and it is granted to community correction for a period of 36 months. Certain parts of that probation that are specifically ordered is that Mr. Johnson, if he doesn't have a current drug and alcohol evaluation, needs to obtain one within 30 days and follow the recommendations thereof. He is to report regularly to his probation officer and submit UAs at her request. All right, so I want to wrap up the sentencing first, and then we will get to the revocation. Mr. Johnson, you have 14 days from today to appeal anything you don't like about your sentence. You also have the right to seek expungement of this conviction after a period of time following successful completion of probation. As a convicted felon, it is prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Do you understand all that?
Yes.
All right. Now, as a distribution of marijuana, I believe while this case is not a mandatory registration, it is a discretionary at the court's option to order that. I declined to do so today. I'm not ordering him to register based on this conviction. Mr. Johnson, what are you doing for a living these days?
I'm currently unemployed right now, but I just had an interview yesterday, so hopefully I'll be employed sometime this week.
Do you have a particular skill or trade that you do?
Forklift.
Okay. So where was this interview?
I'm sorry, I didn't hear what he said. You did.
It was a phone interview with Method Technology for Marriage Source Virgin in Edwardsville.
All right. So I missed, what did you say your trade is?
I'm certified in forklift.
You're certified on a forklift. Okay. All right. And is that what you're being considered to be hired for?
Yes.
All right. All right. Well, I think you will have the wherewithal to pay your court costs and supervision fee. The DNA fee is not necessary. There's no, or he's already in the database. I take it, Mr. Welf, the drugs were not tested in this case?
I don't believe so, Judge.
All right. And Mr. Matthews, do you know what your attorney fee is?
I would estimate at $480, Judge.
All right. I'm only going to order 100 of that along with the bids fee. So court cost, supervision fee, $100 attorney fee, $100 bids application fee, and that's going to be the sum total for the sentencing. All right. So I think that covers everything we need on the sentencing. Mr. I guess, is there any jail time credit?
Yes, Judge. For this particular case, I have 48 days of credit from 9/7/2020 to 10/24/2020.
You agree with that, Mr. Matthews?
I do, Your Honor.
All right, he'll be granted that jail time credit. All right, I think that wraps up everything for sentencing. So let's move on to the violation. There was a violation in the 2017 case filed back in September. It was updated today. It alleges 5 allegations of violation of probation. Mr. Matthews, do you have an opportunity to talk to Mr. Johnson about those, and does he have a position?
Your Honor, I have gone over those with Mr. Johnson, and we would stipulate to the violation.
All right. So it was discussed prior to coming on the record that the recommendations for the parties would be that I accept Mr. Johnson's violation or stipulation, find him in violation, extend him for 1 year from today, and reinstate his probation. Anybody want to add anything to those recommendations?
No, Judge.
No, Your Honor.
All right, Mr. Johnson, anything you want to tell me before I decide what to do on your violation?
No, sir.
All right. Well, I'm going to follow that recommendation. I think it's appropriate in this case. I will find the defendant in violation of his probation. I am going to order the arrest and detain order withdrawn. And I am going to find him in violation, reinstate his probation for a period of 1 year from today. And I think that should cover that. Mr. Johnson, a couple of other things. One thing in this sentence is by operation and law and order of this court, the new sentence shall run consecutively to the old sentence. Look, I hope you know this, Mr. Johnson. One of the problems that the court struggled with here is that this violation, which was basically kind of an abandonment of your probation, happened within 5 months of you being granted it beforehand, if I'm reading those right. Let me make sure. No, I'm sorry. It was in 19 that you were placed on probation. I hope you understand this. The prosecutor has announced his intent that if there are further violations like this, that he's going to seek to have you serve not only the 27th sentence, but the 2020 sentence on top of that. Okay. So look, that to me, that doesn't mean that if you use one more time that you're going to go do, 6 years in prison. But here's what I need you to do. You have to engage in your probation. You have to get in treatment, and you have to get clean. Now, if you have relapses, we can deal with those. Okay. You get back into treatment, you figure out why you relapsed, and you get clean again. All right. As long as you're showing effort, you're not going to have to worry about going to prison. But if you relapse and you figure, oh, I'm done, and you stop reporting, you don't go back into treatment, you're going to force my hand and make me send you to prison. You understand all that?
Yes, sir.
All right. All right. So I think that covers both cases. Mr. Ralph, anything I haven't covered today?
No, Judge.
Mr. Matthews?
No, Your Honor.
Ms. Sanchez, anything you need as far as an order goes that I haven't done?
No.
And Ms. Dorsey, same question? Nope. Okay. We're all good then. We are adjourned. Good luck. Oh, Ms. Lowe.
Hey, Judge.
1 second, Mr. Johnson.
Could you
Yes.
just read off the 2017 case number one more time, please?
The 2017 case number is 2017CR631.
Thank you.
And
Yeah.
Judge, you extended it 12 months from today. Is that correct?
That is correct.
Okay, just double
All
check.
So we're off the record. Yes, Mr. Johnson, you had a question?
Yes, I was wondering, can I get my phones back? I never got my phones back from when I got arrested. Or when I came out of jail, I never got my phones back.
All right.
I will wait 2 weeks because technically, I understand, Mr. Johnson, the odds are you're probably not going to appeal, but I'm going to wait 2 weeks to file an order to release property. And then if you haven't appealed within 2 weeks, we'll get that filed. And then, KCK PD will, they're the ones that handle that. So what I would say is wait 3 weeks and then contact the KCK PD. Okay.
Okay.
We should have our stuff filed by then.
Okay.
All right. Does that answer that question, Mr. Johnson?
Yes, sir.
All right. Good luck to you. We are adjourned. Thank you, everyone. Have a great holiday.